Good morning, everyone. So, has the government moved the goalposts? In some areas, potentially you might argue that the government has moved the goalposts slightly. In other areas, I think they've moved the goalposts one way, then nudged them back the other way, and we've ended up roughly where we started. And in many other areas, it's an early morning kickoff. It's really foggy. We can see the goalposts somewhere in the distance, but only the outline of them. We don't know precisely where they are. We'll just talk for a maximum of 30 minutes today. As Tom mentioned, if you do have any questions, pop them in the Q&A function. Whether I get round to questions or not, I don't know. I can't promise I will do, because I'm determined to keep to my 30-minute time limit and not take up too much of your busy Monday mornings. So we're going to look at a few of the main areas in which announcements and amendments made to the Employment Rights Bill last week have a potential impact on your preparation for the introduction of the Employment Rights Bill. One of the things to mention before we talk about that preparation, one of the important things is we are still very unclear about precise implementation dates. We had that announcement from the government when they introduced the Employment Rights Bill in October last year, saying things were unlikely to happen until 2026. That still seems to be the case, but when in 2026 certain things happen, we simply don't know. So we're a bit unclear on timescale still. Can you pop to the first slide, please, Tom? So one of the things that grabbed a bit of headlines last week were changes to the 0 hours workers provisions, and just a bit of a refresh on what those were and what hasn't changed. So the fundamental and one of the key reforms within the Employment Rights Bill is this concept that there will be a reference period, which we think will be 12 weeks. That's the government's stated preference, but we've not seen the specific regulation saying so. But there will be a rolling 12-week reference period. And if people who are on either 0 hours contracts or low hours contracts work above a certain number of hours during that reference period, there will be an obligation on the employer to offer them a contract with a guaranteed number of hours reflecting those hours over that reference period. The principle behind this being that we get away from, and employers get away from, the uncertainty and insecurity of 0 hours or low hours work. And the second element, which again hasn't changed within the amended regulations, is this idea that those working under these sorts of arrangements should get reasonable notification of when they will work shifts, reasonable notification of changes to their shifts, and reasonable notification of any shift cancellations. And if any of that doesn't happen, then there will be an entitlement to a payment to compensate them for that late notification of any of those elements. So that was all enshrined in the original Employment Rights Bill. That remained the same. The one area of speculation upon which the government consulted was whether or not to include agency workers within those provisions. And there was a dilemma there, because on the one hand, if you exclude agency workers from the provisions because you recognise that we've got a big agency sector, the whole point of using agency workers is to gain flexibility on both sides, etc. If you exclude agency workers and say, yes, that should be separate, then would lots of employers seek to circumvent the 0 hours rules simply by using agency workers? And if that were to happen, then the same workers would experience the same sense of insecurity and uncertainty. On the other hand, we have an agency sector, we have a business that engages with the agency sector, keen to use it for that flexibility. So the government has that dilemma as to whether or not to include agency workers. They have fallen on the side of including agency workers within the provisions and offering agency workers effectively the same level of protections as directly engaged 0 hours or low hours workers. Not simply, but largely because they want to avoid there being that loophole to these regulations of being able to use agencies. So agency workers will have the same right to be offered guaranteed hours, and those hours will need to be offered by the end user, so the client of the agency. They say that regulations may provide some exemptions for that, but generally speaking, if you, as an end user, have been using the same agency worker for a certain number of hours within that reference period, you will have an obligation to say, right, from now on, you have guaranteed hours with me of X hours per week. In terms of late notification of shifts, cancellation of shifts and changes to shifts, that will be a joint responsibility between the agency and the end user. If that reasonable notice isn't given, then liability to make a payment, i.e. to compensate for that late notification, will fall on the agency. And that is because it is the agency that is the one paying the worker. So that is logical. However, what the government are clear on is that the agency can agree in its commercial agreement with its end user to pass that cost on to the end user, which would seem sensible because normally, of course, it will be the end user cancelling the shift on short notice or engaging someone on short notice or changing the shift on short notice. So whilst technically the legal obligation will be on the agency to pay that compensation, we would expect commercial agreements between agencies and end users to pass that cost on to the end user. So for those of you who do engage a large number of agency workers in relation to your planning for the implementation of the Employment Rights Bill, whenever it happens, this is something you will need to be considering. In effect, the same obligations will apply to agency workers as 0 hours workers. There is a potential exclusion for employers who are unionised, in that the government recognise that these regulations are quite complex, will cause a considerable burden on employers. They have not heeded the request of employers' organisations, including the CBI, for example, to move this away from the employee being entitled to be offered guaranteed hours to a right to request. The government have said, no, we will keep it with an obligation to be offered, which imposes considerable burden on employers. But what they have said is you can come up with your own rules for what you will do to offer guaranteed hours to 0 hours workers or agency workers in a collective agreement with a trade union. So you don't have to follow the Employment Rights Bill provisions if within a collective agreement that forms part of an employee's contract, you come up with a different solution that suits both parties. So that's something that may happen. In terms of what hasn't been clarified, I've mentioned that the government had indicated there will be a 12-week reference period for calculating how many hours have been worked. That hasn't yet strictly been confirmed, but we do expect that to be 12 weeks. The threshold of hours within that reference period that will trigger a right to be offered guaranteed hours hasn't yet been confirmed. There is not an indication yet of what will constitute reasonable notice of changes to shifts and cancellations. There is a suggestion that the offer of a contract made of guaranteed hours to 0 hours workers can't be for a fixed term unless it is reasonable to do so. And again, we don't know what will count as reasonable. And finally, arising out of the consultation, there have been some representations made about whether there ought to be some sector-specific exemptions, a particular one being the Local Government Association talking about retained firefighters, who might only be called out very irregularly. If there is a spate of call-outs, they would say, well, it goes against the fundamental spirit of the model for us then to have to offer guaranteed hours to retained firefighters. So that is one particular area where there might be a sector-specific exemption. Next slide, please. Statutory sick pay. Again, in terms of what hasn't changed, you'll hopefully all be aware that the Employment Rights Bill had clarified that we would no longer have 3 waiting days for statutory sick pay. There would be statutory sick pay from day 1 of absence, which would be an increased financial burden on employers in terms of paying statutory sick pay, but that was the principle, and that principle remains the same. We have a further extension of statutory sick pay now to low earners. So at the moment, in order to benefit from statutory sick pay, you have to be earning at a certain level. And the government was concerned that, according to its statistics, 1.3 million people are below that level, and therefore, when they are off sick, receive no sick pay. And they consulted about what an appropriate level of sick pay would be for those people who didn't reach the earnings threshold and didn't reach the current statutory sick pay rate. And the answer they've come up with is 80% of their earnings. And that will also be from day 1 of employment. And what they say is that will provide enough financial security for lower paid employees to help protect them from feeling forced to go to work when they're unwell, reducing presenteeism and the spread of infectious disease, and therefore increasing overall productivity and helping to protect the National Health Service. They didn't put it to 100% because they said, well, we can see why employers would feel 100% was A, expensive, and B, would act as a potential disincentive to come to work. And so they feel that 80% is about the right level to strike that balance between protecting lower paid employees, enabling them to take time off sick, but at the same time not being so high as for people to think, I might as well take the day off. There is still some scepticism in some employers' quarters about that, because they have made representations to the government saying, well, look, once people take into account saved travel costs, etc., and the time saved by not going into work, we think 80% is a bit high, but that's where it is. Moving forward for businesses then, those businesses who were doing cost modelling based on the removal of waiting days will also want to do cost modelling on whether they have a population of workers currently under the earnings threshold, not receiving statutory sick pay, who will in future be entitled to statutory sick pay, and to assume that that will be payable at 80% from some point next year. Next slide, please. Some changes on collective consultation obligations. So this is the obligation where there are 20 or more redundancies to collectively consult either with the trade union or with elected representatives. From the employee side, the government are keen to ensure that employers are abiding by their collective consultation obligations, both in the context of traditional redundancies, i.e. job losses, but in a fire and rehire context as well. And in order to provide employers with an increased incentive to comply, the government will increase the maximum protective award, which is currently 90 days pay per affected employee, to 180 days pay per affected employee. So that's a hefty penalty for getting it wrong. On the other hand, what the government have said to employers is, yes, but we've not gone in as harshly as we might have done. And the two particular elements of that is, one thing they were considering doing was making available the remedy called interim relief in respect of collective consultation exercises. Interim relief is a remedy available in relatively few circumstances at the moment, but it's effectively where the tribunal intervene and prevent the dismissal taking effect until there has been a judgment as to whether or not the correct process was followed. So that was one proposal put forward, but the government have said we're not taking that forward. So the penalty for failure will simply be that financial penalty. The second thing that they've done in this amended bill is quite important. When the bill was first announced and when the government announced their intentions, they said that they proposed to get rid of the establishment requirement. So at the moment, an employer has to collectively consult if it proposes 20 or more redundancies within a 90-day window at one establishment. So if it has, Woolworths was the famous recent example where there were a number of different outlets, number of different stores, lots of them employing fewer than 20 employees. There was no requirement to carry out a collective consultation because they were separate establishments. And the government said, we're going to get rid of that establishment requirement. It will simply be how many employees you propose to make redundant across your business, which would have meant a lot more redundancies come within the scope of collective consultation. And there will be some employers who would, because they're so large, would probably be on a rolling collective consultation process, because within the business there would always be 20 or more redundancies potentially. Last week's amendments say they will no longer be removing that establishment requirement. So the requirement to collectively consult will still be 20 or more redundancies within a 90-day window at one establishment. Good news for employers. However, what they said they may be entitled to introduce, and what we suspect they will introduce, is there will be a threshold of a certain number of redundancies, but they haven't yet confirmed that number, where collective consultation will be triggered by business-wide redundancies. So the rules might in future be, if there are 20 or more redundancies at one establishment, you have to collectively consult, or if there are 50 redundancies across your whole workforce, or 100 redundancies across your whole workforce, or 30 redundancies across your whole workforce. We don't know what that number will be, and obviously we need to know that number. But the principle is that's how the legislation will operate in the future. In terms of the fire and rehire provisions that were brought in or announced in the original bill, there's been no substantive changes to those, in spite of representations from businesses suggesting that they thought they were unworkable. Just as a reminder, those provisions were any employee who is dismissed for failing to agree to a new contract of employment will be deemed to be automatically unfairly dismissed, save in some very exceptional circumstances where the fire and rehire exercise was because the business would go bust otherwise and was in severe financial distress. Businesses suggested that the provisions were unworkable, that automatic unfair dismissal was too heavy a punishment for the crime, and that it would act as a real barrier to changing terms and conditions of employment where it might be reasonable to change them. But as we stand at the moment, there haven't been any substantive changes to those fire and rehire provisions. So the position will be as announced in October. Next slide, please. Industrial relations was a big theme, as you might expect from a Labour government, in respect of the Employment Rights Bill. And they've done some tinkering with the industrial relations provisions within the bill for the benefit largely of trade unions, but to a certain extent to provide a balance between unions and employers, as we'll see in the last point. In terms of balloting and balloting for industrial action, those of you familiar with the process will know it is already a very technical process and an easy process to slip up on. And if a union slips up, then any industrial action will be unlawful and there could be liability flowing from that. And it is a complex process, some might say deliberately complex process, to limit the scope for taking industrial action. So some of the reforms make the balloting paper that trade unions have to use a simpler paper. They will no longer have to provide information as to the number of employees concerned in each category or workplace, or provide an explanation as to how they've determined the total number of employees. The government says it remains committed to e-balloting. At the moment, provisions require a postal ballot, which doesn't really suit the modern world, but they are looking at ways of regulating electronic balloting to make that fair, secure, and transparent. The bill announced increased rights of access of trade unions to workplaces, and the amendments last week clarify that access includes digital access. And the example of that given is something like, well, traditionally, unions had a right to a notice board in the workplace. Physical notice boards may no longer exist in the workplace, so this might include a right to have a page on the company's internal intranet and for them to be able to post news items and share information on the internet. In terms of the recognition process, it is anticipated that as a result of the Employment Rights Bill and the provisions generally, that more trade unions will seek recognition agreements in relation to workplaces. And there is a statutory recognition process to be followed if employer and trade union cannot consensually agree to a recognition agreement. Last week's provisions increase the ability to prevent unfair practices by employers within that statutory process. So, for example, there's a code of practice that will be extended to cover the whole of the recognition process, start to finish, which it doesn't at the moment. Employers will have to share within 10 working days of the application being submitted the number of workers in the proposed bargaining unit, and will be prevented from altering that number in relation to statutory recognition applications. There'll be a maximum of 20 working days for an access agreement to be agreed, and if it can't be agreed within that time, it will go to the CAT, the Central Arbitration Committee, to adjudicate and to issue an order requiring access to the workforce. It will be made easier for unions to challenge unfair practices from employers. At the moment, they would have to challenge and show that the way in which an employer had conducted himself had influenced the outcome of a ballot. They will no longer have to show that. They will simply have to show that it was an unfair practice. In terms of industrial action itself, one thing they've proposed previously, it suggested the notice for industrial action had to be 7 days. That will be extended to 10 days. So that operates in an employer's favour. Employers will have more notice of industrial action. The flip side of that is a ballot for industrial action won't last for 6 months, now lasts for 12 months, and give the union the ability to take strike action within a 12-month window rather than a 6-month window. So considerable strengthening of the position of trade unions, both within the original bill and within last week's amendments. Next slide, please. Umbrella companies. And the consultation paper on this was called Tackling Non-Compliance in the Umbrella Company Market. Point to make here is this isn't a Labour Party thing. This was a consultation launched in 2023 by the previous government about concerns with the way in which umbrella companies were operating and the lack of regulation of them. So umbrella companies, for those not familiar, are effectively companies that step in traditionally in between employment agency and end user, and the umbrella company engages and employs and pays the number of employees. But the concern was that that made the landscape of employment relationship increasingly difficult to navigate for workers. It wasn't always clear to them whether they had employment rights or who was responsible for them. So the two amendments here are that umbrella companies will now be defined, and they will come within the scope of the Employment Agency Standards Inspectorate at the moment to become the Fair Work, or will fall under the Fair Work Agency when that gets established in due course. So they will be regulated in the same way as recruitment agencies and employment businesses. The second area of reform is in separate legislation, so not in the Employment Rights Bill, but is a consequence of it. This is from April 2026. At the moment, PAYE responsibility lies with the umbrella company, and the government statistics suggest that £500 million has been lost to tax avoidance schemes, and a large portion of that can leave individual workers with the tax bill if the umbrella company, for example, no longer exists. So what will happen in April 2026 is PAYE responsibility will move from the umbrella company to the recruitment agency, so they have a vested interest in making sure the tax treatment is correct. Where there's no agency in the chain, then responsibility will lie with the end user. So effectively suggesting that someone will carry the burden of ensuring the correct tax treatment. Next slide, please. Okay, just before we finish, last couple of minutes, a few other things. So those previous slides were all specific consultations to which the government were responding in the amended bill. These are a few additional points that have been put into the bill. The first is there will be a new obligation on employers to keep adequate records of holiday pay. So at the moment, they have an obligation to keep adequate records of working hours. This will extend to adequate records of holiday pay. Those records will have to be kept for 6 years, and it will be a criminal offence to fail to keep them. So for employers who have workforce who have a lot of non-salary payments, overtime, etc., where you're having to do complicated holiday pay calculations or using rolled up holiday, whatever it is, for all employers, that's something you need to be planning for. To the extent that you don't at the moment, you will need to keep those records of holiday pay. The Fair Work Agency, which the government announced in the original bill, would be responsible for enforcement of all forms of employment rights, so bringing together the different strands, because at the moment sometimes it's HMRC, sometimes it's EHRC, bringing together everything, will get significant powers. They will have the power to bring claims on behalf of workers in the Employment Tribunal. And the second important one is they have the power to enforce payments due to employees. So this is similar to national minimum wage at the moment. So HMRC can issue a notice to an employer requiring them to pay both national minimum wage owed to employees and a penalty. The same will apply to other statutory payments due to employees. I think the potentially important one here is holiday pay. So employers who don't correctly pay holiday pay can't just think, well, employees might not bring a claim. Because even if employees don't bring a claim, the Fair Work Agency can issue a notice of underpayment to the employer, requiring the employer to make that claim, and can impose a penalty of up to 200% of that sum, up to a maximum of £20,000 in addition. So the cost of not paying holiday pay or sick pay or anything, any other statutory payment, particularly holiday pay, could now potentially come not just the cost, but the penalty of up to 200% as well. Final thing they do, in my last 30 seconds, the government clarified, and they clarified this in January, that the time limit for bringing an employment tribunal claim would extend from current 3 months to 6 months, so people will have longer to bring claims. So all of those changes there make it more likely that employers will face either employment tribunal action or enforcement action from the Fair Work Agency once it's in place. Thank you for listening. I'm sorry I haven't had any time to deal with any questions, but the promise was 30 minutes and I'm about 30 seconds late on that promise. Apologies for that. Enjoy the rest of your Monday. Thank you.